If you're an AI developer working in the EU, you're probably grappling with a huge question. How do you build truly innovative AI using personal data without falling foul of the world's toughest privacy laws? Well, today, we're going to break down the EU's answer to that puzzle, a unique testing environment known as the regulatory sandbox.
And this really is the core dilemma, isn't it? On one hand, you need massive amounts of data to train powerful, effective AI systems. But on the other, you have this absolute fundamental duty to protect people's privacy and their rights. How do you possibly reconcile those two things?
It's like two powerful forces pulling in opposite directions. Data is the engine of progress. It's how AI can help us spot diseases earlier, build a sustainable energy grid, and make our infrastructure safer. But at the same time, the EU has this ironclad commitment to protecting personal data, with laws like the GDPR at its very core.
So the EU's solution is to create a space to bridge that gap. It's a controlled, supervised environment where innovation can happen, but within very strict guardrails. And this is the AI regulatory sandbox, which is laid out in Article 59 of the new AI Act.
Okay, so here's how we're going to walk through this. We'll start with that core data dilemma. Then we'll look at what it takes to get your sandbox entry ticket. From there, we'll cover playing by the rules once you're inside. After that, we'll talk about transparency and documentation, how this all connects with other EU laws, and we'll wrap up with the big picture, the blueprint for trust.
All right, so first things first. You can't just decide to use the sandbox. You have to earn your place by proving that your project is both incredibly valuable and absolutely necessary. And getting that access really boils down to passing two critical tests. Think of them as the gatekeepers. You have to show that your work serves a real public good, and then you have to prove that you absolutely cannot do it without using personal data. So let's look at that first hurdle, the public interest test. Your AI project can't just be about commercial gain. It has to serve a higher purpose. You need to demonstrate that it makes a real contribution to one of these 5 key areas, things like improving public health or helping with the green transition. This is about tackling society's biggest challenges. And then comes the necessity test. And this is a really crucial point. You have to prove that using personal data isn't just helpful, it has to be indispensable for your high-risk AI system. And remember, high-risk systems are those that could seriously impact a person's safety or their fundamental rights. You have to show that other options, like using synthetic data or fully anonymized data, just won't cut it. It can't be a matter of convenience, it has to be essential. Okay, so let's say you're in. You've passed the tests. Now, you've got to operate under a very strict set of rules, all designed to make sure that this innovation doesn't come at the expense of privacy or safety. Rule number 1, you have to build a digital fortress. The sandbox must be a functionally separate, totally isolated environment. We're talking about heavy-duty encryption for data, whether it's sitting on a server or being transmitted. We're talking multi-factor authentication and really strict role-based access controls so only the right people can get near that data. This next rule perfectly sums up the sandbox philosophy. What happens in the sandbox stays in the sandbox. Now, you can share the original data you brought in with other participants, but only under strict GDPR rules. Here's the kicker. Any new personal data your AI generates inside the sandbox cannot leave, period. This is a powerful way to prevent mission creep and protect people's information.
And this is absolutely non-negotiable. The fundamental rights of individuals always come first. Being in the sandbox is not a free pass to ignore privacy laws. People must always have the right to access their data, to correct it, or to have it deleted, just like they would under standard GDPR. And finally, when your work is done and your time in the sandbox is over, that data has to be securely and permanently wiped. This reinforces a core principle of data protection, data minimization. You only keep what you need, for as long as you need it, and then it's gone. For good.
So you're in the sandbox and you're following all these rules, but how do you actually prove it? Well, the next piece of this framework is all about building public trust through radical transparency and meticulous documentation.
You're actually required to keep 2 parallel sets of records. On one side, for the regulators, you need deep technical documentation. We're talking the real nuts and bolts of your algorithms, your data sources, and your risk assessments. But for the public, you have to provide a clear, accessible summary of what your project is about and what you found, all in plain language.
Now, what's really helpful here is that the Act points towards established industry best practices to meet these requirements. Things like model cards, which are becoming a standard way to report on an AI's performance and its limitations, and data sheets, which give you a transparent look at your training data, Where did it come from? How is it collected? And what biases might be lurking inside it?
It's also super important to understand that this sandbox doesn't exist on an island. It's designed to be a key part of the EU's much bigger digital strategy, interlocking with other major pieces of legislation.
Your sandbox project has to be in sync with a whole suite of EU laws. The GDPR, of course, is the absolute foundation. If your AI is going to be used on an online platform, the Digital Services Act and its rules on risk management will apply. And if you're hoping to use public sector data, the Data Governance Act sets the rules for that. They're all designed to work together as a coherent system.
So, after all that detail, let's zoom out. What's the big picture here? What's the ultimate goal of this entire carefully constructed framework?
The main thing to take away is that these rules aren't designed to be a burden or to slow down innovation. They're meant to be a strategic framework for building trust. The idea is that by proving AI can be developed safely, ethically, and transparently, we can increase public acceptance and really allow the technology to flourish in a responsible way.
This quote from an analysis of the Act's development really captures the core philosophy perfectly. At every single stage of the legislative process, the rules around protecting fundamental rights were strengthened. It shows this unwavering commitment to building AI that serves people, and not the other way around.
And all of this leads to one single massive benefit. That's what this one on the screen represents. It's about having one harmonized framework across the entire European Union. Instead of trying to navigate a messy patchwork of 27 different national laws, developers get one clear rulebook. This creates legal certainty and a level playing field for everybody. Which leaves us with a final question to think about. Is this incredibly detailed and demanding rulebook a barrier that's going to stifle innovation in Europe? Or is it the essential blueprint we need to build the kind of AI that society can actually embrace and trust for the long haul? The answer to that is going to shape the future of technology for all of us.